and supporting volunteer guardians. He currently serves as its Director of Education. They are partners in a law practice in Pennington, and I'm pleased to have Tony and Nina with us, and I'll turn it over to them.
Okay. Thank you, Dot. I appreciate that and the kind comments. And I welcome everybody who's listening to us. My name is Tony Serra, and I'm here with my partner, Nina Weiss. And we're going to spend the next 40 or 45 minutes or so talking about guardianship law, how to obtain it, and also some of the rules that come into play when you are a guardian. And this is a topic that we could spend several hours on, so we're going to try and get through this at least in a general way, so you have a pretty good understanding of what it takes to actually apply for and become someone's guardian. But before we get into the real particulars of how to do it, the nuts and bolts of it, we thought it was helpful to get an understanding of the philosophical basis for guardian, and also take a quick look at the history of it. I think if you understand the philosophy behind it and why we have guardianship law, I think you'll have a better understanding of what the standards are when you become guardian and how to act as guardian. But philosophically, it's the case that all adults are presumed competent. It's really a constitutional requirement, and no one really argues that point, that all adults are presumed competent. And we reach adulthood at the magic age of 18. Now, why is it 18? Well, it's somewhat arbitrary. I guess the law could have made that 17 or 19, but the law has identified 18 as being legally able to engage in an array of activities that someone at 17 couldn't do. And this is entering into contracts or giving informed medical consent, or just generally making decisions about where to live. So although as a parent you may not notice a difference in your son or daughter, when they wake up on their 18th birthday, in the eyes of the law, there's a significant change. Legal status has changed considerably. So that they're now adults, they're afforded the same rights and responsibilities as all adults. And this is why on a Wednesday you can access your son's or daughter's medical records, but on the very next day, on Thursday, the doctors won't listen to you because they're 18 and they have a right of privacy just like their parents do. Now, simply believing someone is incapacitated, even if that's supported by medical evidence, does not render the person incapacitated. Even if there's no question that a person lacks capacity, a lay or medical opinion alone does not render the person incapacitated. You need a court of law to render somebody, an adult, incapacitated. Now, historically, excuse me, our guardianship law derives from the English concept of parens patriae, and it's an Old English common law concept that the king would take care of his subjects who were unable to take care of themselves. Of course, back then it really meant the king took all the money from people. But in the last 40 or 50 years, when we adopted that doctrine, in the last 40 or 50 years, it's become more of a civil rights issue, and we've become more sensitive to this notion that people, have a right to independence and to choose. And so there have been laws now that have been passed that that now take us through a process of making sure that if we start taking these rights away from folks, that it's done correctly. So the law has grown up in the last 40 or 50 years, but it's rooted in this notion that we're trying to benefit people, we're trying to protect them against self-neglect and harm, and it's intended to shield a person from undue risk of harm, and it's not intended to punish anybody or to cause harm. But there is a very delicate balance between protecting people with diminished capacity and promoting and preserving their right to choose and their right to be make their own decisions for themselves. Okay, so we're going to start getting into, that was a little bit of a background of the
paradigm under which we're proceeding in the guardianship. But now we're going to get into a little bit of the nuts and bolts of exactly how you go about filing for guardianship in the courts in New Jersey. As Tony mentioned, just by saying or believing someone's incapacitated is not sufficient to have access and to make decisions. You must file an application in the Superior Court of New Jersey, and you file ordinarily where the person, the county where the person is residing. Guardianships are treated as an adversarial proceeding where the plaintiff, who's the person seeking guardianship, so if you're a parent over a child, you would be the plaintiff, you must prove the need for guardianship by clear and convincing evidence. It's interesting that it's treated as an adversarial proceeding. You know, as Tony mentioned as the background, we're trying to do what's best for someone, but at the same time it involves, you know, taking someone's decision-making authority away and vesting it with someone else. So technically it is an adversarial proceeding. The action's being filed technically against somebody. So the legal process requires the filing of several documents. First, the verified complaint, which is a document that essentially starts the action, and you're explaining to the court what you're looking for. You also need to file 2 medical certifications supporting the application and a certification of assets, and we'll get into this further along. The verified complaint must set forth certain basic information. It doesn't have to be overly detailed, overly long, but there has to be certain minimum information that you need to set forth to the court. The person's name, the address, and where they're currently residing, the plaintiff's relationship to the AIP. The AIP is the alleged incapacitated person. So either a mother or a father, or, you know, if it's Adult Protective Services, it could be a client. You also must set forth the name and best known address of the person's next of kin, which would be a spouse, children, siblings, and parents. And this is because these people will be entitled to notice of the application. So when you file the verified complaint, these people will be copied on the papers. You also must set forth the known assets, liabilities, and income of the person, and generally the factual basis for the guardianship, which basically means, you know, a brief history of their situation, whether it's a developmental disability or an elderly individual who's suffering from a dementia, and a little bit of factual background of what's been happening to the person and the need for guardianship. As we said, it must be supported by 2 medical certifications. This is essentially the evidence that's presented to the court to show the need for the guardianship. You need 2 independent doctors, and they must be able to provide a diagnosis of an existing medical condition that renders the person unable and unfit to manage his or her own affairs. Now, oftentimes, the medical certifications can be quite cookie cutter and generic, but oftentimes that might not be sufficient. It's very important for the attorney, when they're speaking with the physicians who are filing the certifications, that they explain the connection between the diagnosis and the need for guardianship. So for example, if it is a developmental disability, you need to say what that disability is and how that's impacting the person's life and why they can't make certain decisions. Another interesting requirement is that the complaint must be filed within 30 days of the physician's examination. So for example, if you have a child who's been seeing the same pediatrician for his entire life, and you last saw the doctor maybe 6 months ago for a general exam, you'll need to go back and have the doctor reevaluate your child for guardianship, because otherwise it would be considered stale. There are rules where the court can relax that requirement if it's a little bit out of date, but generally speaking, it has to be a recent exam within 30 days of filing the complaint. At least one certification must be from a medical doctor, and a recent rule change has said that the second may be from a psychologist who has a PhD. We'll speak about the importance of that later when we discuss limited guardianships, but oftentimes the psychologist can be very useful in giving the court a lot of background information about how the person is functioning day to day. The certification of assets is pretty straightforward. It essentially must set forth the person's assets, liabilities, and income as best as they are known to the person filing the application. And the reason why we say as best as they are known is because, by definition, the plaintiff is not yet the guardian, and they may not have access to all of the financial information. So essentially, it's a best guess of what the nature and extent of the assets and income are. What will happen, we'll talk about later again, is once you become guardian, you'll file supplemental documents with the court to show actually what the person has. But this, again, is just an estimate of what you know at the time when you're filing the application. It's necessary to make this disclosure so that when a guardian is appointed, we'll know whether or not to set a bond, and if so, the amount of that bond. And generally, the bond should be the amount of the assets in the estate so that it's all protected. The disclosure is also important for developing an appropriate care plan and the possible need for Medicaid planning or a special needs trust, depending if there are assets but that they do need some Medicaid benefits, there might be a need for the creation of a trust. That's for another day. That'll be for another webinar. As we said before, a guardianship is an adversarial proceeding. It's filing an action against somebody, and it involves taking decision-making authority away from someone, investing it with someone else, so it can represent a significant infringement on a person's right of self-determination and autonomy. And for that reason, there are several due process protections put into place. Right to notice, which means you can't file a guardianship without the alleged incapacitated person knowing, which sometimes is a factor. I mean, we'll meet clients from time to time who may not want to disrupt the apple cart as of yet and file an application, let's say, against their mother or their father and create what might be animosity in that relationship. So it can't be done without the person knowing. The person has a right to notice. Actually, get personal service of the court papers. The person has the right to an attorney, and we'll talk about that again a little later. There's a right to a hearing and an opportunity to testify in court. There's a right to cross-examine experts and witnesses. So, for example, if the person alleged to be incapacitated objects and doesn't want a guardian, their attorney might call in the physicians who certified as to the incapacity and cross-examine them on the stand. We've seen that, and it's very possible. Again, only in a contested matter would that happen. There's also a right to a jury trial, which we've never really seen, but there is that right that the person can ask for a trial by a jury. 99.999% of the time, there's a hearing before the judge, but the alleged incapacitated person can request a jury if they want. And there's a right to an appeal. Once the application is filed, the court will appoint an attorney to represent the person alleged to be incapacitated. And this is not, this is a mandatory requirement. It's not discretionary by the court. So if you file a guardianship, let's say for your child or for your parent, and you see that the court has appointed an attorney, that will not be unique to your case. In every single guardianship matter, an attorney is always appointed for the person. Actually, the person even has the right to retain their own attorney if they don't want court-appointed counsel. But generally, they accept court-appointed counsel, and that is in every single guardianship matter. And what's important for you to know as parents or as plaintiffs filing a guardianship is what the role of the attorney is so that you're not surprised about what happens during the course of the proceeding. The court-appointed attorney's role, very simply, is to be a zealous advocate for the stated wishes of his or her client, which basically means they're an attorney like any other attorney. If you go and retain an attorney, you expect that attorney to be loyal and faithful to your interests and to advocate for what you want. And a court-appointed attorney is no different. That is their role. So essentially, they maintain, to the extent possible, given the fact that by definition they are working with someone with a disability, they're to maintain a normal attorney-client relationship to the extent possible. They're also to interview interested parties and close family members and to advocate for less restrictive alternatives to a full or plenary guardianship, which could be a limited guardianship or a power of attorney or a living will. They're also to determine if a client has a will, a power of attorney, or a living will. And they also are to determine if additional medical evaluations may be necessary. For example, if the person feels that they don't need a plenary guardian and the attorney is advocating for a limited, they may need to get an additional medical evaluation supporting the need for a limited guardianship. After their investigation and meeting with the client, they issue a report to the court, and they recommend whether a case plan should thereafter be submitted. Some of you may have heard of the case, the matter of MR, in your travels in this field. Generally, without going into the facts of the case, it did involve a developmentally disabled young girl who had just turned 18, whose parents were divorced, and she was voicing a preference to live with the father rather than the mother. And the mother had filed for guardianship and essentially said, since she's globally incapacitated, she loses the right and the ability to make the decision about where to live. And what ultimately happened in the Supreme Court in New Jersey was that they said that it was the mother's burden to prove that her daughter lacked that capacity to make that decision. So in other words, this was the first time the court really recognized that we could have a limited guardianship. In this particular case, she was generally incapacitated and unable to make most decisions, though it was specifically stated that she may retain the ability to decide which of her divorced parents she wanted to live with. So it was a very seminal case in New Jersey, and the case is cited many times in reports of counsel in these matters. A court may also appoint a guardian ad litem, but it's important to know that the role of the guardian ad litem and the court-appointed attorney are very, very different. You may not always see a guardian ad litem, and generally speaking, in an uncontested guardianship, you probably won't see one because it's not mandatory, it's discretionary by the court. But the court may appoint a guardian ad litem if it determines that the person is espousing a position that is, quote, patently absurd, or where there are, quote, special circumstances. And you may say, what does that really mean? What is patently absurd and what are special circumstances? And essentially that's dealt with on a case-by-case basis. You know, it's really hard to say. You know, I guess if a person says, I want to go live on the moon, that might be patently absurd. But if they want to continue living in their house where there's a lot of hoarding, that may not be. There's a fine line between, you know, what's acceptable and what's not. So essentially, the role of the guardian ad litem is to give a best interest evaluation, regardless of what the person is asking for. So this is a more objective approach. Whereas the role of the court-appointed attorney is to advocate for what the person wants, regardless of what the attorney believes is in the client's best interest. So this is a more subjective approach.
Okay, now, in order to file for guardianship against somebody, you have to have some relationship to that person. Right? We just talked about that earlier, about you know, who can file. But in legal terms, you have to have standing, and that's really means the right to file. And you know, a mere stranger cannot file, and that's for obvious reasons. You just don't want, you know, people who may have other, you know, another interest, their own interest to file, being able to do that. You really have to have some interest in that person. Usually it's a family member, but as we pointed out before, it can be if it's somebody in the community, if it's an adult protective service situation where there's some abuse or neglect, that agency will come in and try and resolve the situation and try to offer services. But if they feel the person, is not accepting the services or is not able to really comprehend what's being offered, in many cases they will file for guardianship in order to have a plan put into place. We've seen financial institutions who might be trustee for somebody, where that person now is no longer able to manage effectively. They can file, and in many cases, hospitals and nursing homes file. If there's a medical decision that has to be made, and the physicians feel that the person cannot give informed consent, they will file. There's something called a special medical in case of a procedure that has to be taken care of right away. There's procedures for that. Nursing homes file a lot in order to collect their fees and their costs because the person is not paying the bill, and you can't find the family, and the family's not paying the bill. So that could also trigger a guardianship. And we've also seen private care managers actually be in a position to file. The legal standard for declaring somebody incapacitated, and we quoted it here on this slide, it's a very broad standard. And it's essentially a finding that a person is unfit and unable to govern himself or herself and to manage his or her own affairs. It's not very specific, but that's the standard, and it allows the court to have some freedom to judge different situations. If the court makes that finding, they may appoint a general guardian who will exercise all rights and powers over that person. And as Nina mentioned before, the case must be proven by clear and convincing evidence, which is a relatively high burden of proof. We hear in these criminal cases the standard is beyond a reasonable doubt, and this standard is slightly less than that. It's not quite the standard you would have in a criminal case, but it's certainly more than a civil case. The standard for a civil case would be, by a preponderance of the evidence, which is 51% or more. Here it's in between those two standards, so it's a relatively high standard. So essentially in a guardianship, the court is going to make two determinations. They're going to first make the determination of whether the person needs a guardian, and maybe the proofs are not sufficient enough, or maybe a court-appointed attorney gets another doctor to contest those reports. So you could have a case where a person is not found to be incapacitated, and that could be a reason the case could be dismissed. Another reason could be that there might be an alternative to guardianship. The person may have capacity to enter into something voluntarily, like the power of attorney or a living will, or a conservatorship, and that's a court proceeding, but it does contemplate someone who has a need but is competent to have somebody appointed to be their surrogate. So that could be another reason why the case doesn't go forward. But once the court makes a finding the person is incapacitated and needs a guardian, then the second question is, who that guardian should be. And in most cases, if it's contested, that's the issue, because people are going to be fighting over, over the control of that person's life. So, if the court determines that a person is unfit to manage his or her own affairs, a guardian will need to be appointed both over their person issues, their medical, meaning their medical and social and residential issues, and also over their property issues, over the management of their assets, of their income. So typically the same person is appointed to fulfill both of those roles, to be guardian of the person and of the property. But in some cases the role can be split, and it can be done in different ways. You can have one person guardian of the property, another person guardian of the person, one of the property, one of the person, depending on their interests and their expertise. Or you can have co-guardians, where you have two people sharing that responsibility over both person and property. And I just had a case we resolved, and we have 3 people actually, three kids. And so you can be somewhat creative, but the problem is the more you have, the more potential for conflict. So the courts are generally not that happy appointing more than one person. If the court makes a determination the person needs a guardian, they will enter what's called a final judgment of incapacity, and that's the formal document that you get with the judge's signature on it, and it'll it could be 4 or 5 or 6 pages long, and it's got the language in there as to some of the duties and responsibilities of the guardian, responsibility to file accountings and inventory, to have access to medical records. So depending on who's drawing up the judgment, some are a little more comprehensive than others, but it'll certainly declare the person incapacitated, and it'll also appoint those fiduciaries, the guardians. When you are appointed the guardian and your name is in that final judgment, you're not really the guardian yet. You have to go to the surrogate's office in the county where that case was being heard, and that's a county office. The surrogate is a county office, and you have to qualify. And what that means is essentially sign papers that you are accepting that appointment. It's very close to the situation where someone appoints you as executor of their will. Just because someone appoints you executor of their will doesn't mean you are the executor or executrix. It just means they want you to do that. You could not accept that, and the state will have to find somebody else. But if you accept the role of executor, you have to go and qualify. That means accept the position. So the same thing here. The judgment will appoint you, but if for whatever reason you don't want to do it, you don't have to qualify. In some cases, there is a bond required, and as Nina mentioned before, that's a requirement in some cases. And just so you know, a bond is not a liability policy. It doesn't protect the guardian from liability. It actually is almost the opposite. It really protects the ward from potential bad acts by the guardian. So that's what a bond does. But don't be offended if a court, wants to bond you. I get appointed in case, we get appointed in cases as attorneys, and we have to be bonded as well. So most judges today are really bonding everyone. Maybe a very close family member, maybe not. But the policy now is essentially to have everybody bonded. Unfortunately, it costs money, but that's just the price of this sometimes. Once you get your bond and you accept your role, then the surrogate will issue letters of guardianship, and that will be the official document that you'll use to go to the banks and make transactions and conduct business. The scope of guardianship. Okay, guardianship could be either full or plenary, or they can be limited. Again, the legal term of plenary means full, and that's really ought to be reserved for individuals who lack really all capacity to make decisions for themselves. The obvious cases of someone who's in a coma or severely handicapped in some way, who really lacks all the ability to express preferences, this clearly would fall within that category. But in some cases where there's some retention of capacity, the right tool then is the limited guardian. And as Nina mentioned before, the 1994 case of MR was really one of the first times that our court recognized that the law views these things on a sliding scale, that there are degrees of diminished capacity, and the law really hadn't caught up with the medicine at that point. But from 94 on, there's been talk about it, and the statute was changed a few years ago to specifically now talk about that this can be a possible outcome. And in many cases, in many areas, we talk about least restrictive approach. We do that in the education field. Well, that's certainly true here. You don't want to have more restrictions than are what are necessary. So you want to go with the least restrictive approach. If there is a basis for a limited guardian, that should be considered. And also, as we mentioned before, now that you can have a psychologist as one of the certifying doctors, it would be helpful to have a psychologist do a functional assessment if you did feel that the person retained some capacity, because that psychologist may be able to articulate a little better, what capacity that person can retain. Because that has to be in the judgment. You have to articulate that and reflect that in that judgment of that final judgment that we talked about. Accountability. Okay, so this is a big issue. As we mentioned before, when you file your complaint, your certification of assets may not be comprehensive because you're not guardian yet. You may not have access to a person's finances. But once you become guardian, you need to reach out and and discover what the assets are, and look through the mail. If it's a situation where things are scattered, check the mail for statements, go through unopened mail or go through files, and really try to identify and marshal those assets. And then you'll be required to file an inventory, which is sort of a snapshot of what those assets are within 90 days of your appointment. The court figures that within 90 days, you should have a pretty good handle on what the assets are. You will then have to file annually what's called an informal final accounting. And that's, in the relatively simple cases, it's really nothing more than a check register showing your starting balances, which really should tie into your 90-day inventory. So if your 90-day inventory is saying there's $125,000 in assets, then your accounting should really start with that balance. Obviously, take into account any income for the year and then any expenses, and then your ending balance should reconcile. You're also required to file, along with your financial accounting, a report of well-being, so the court can get a sense of how they're doing medically and in terms of their living environment. You need to keep a good sense of what's happening in that regard, so you can report to the court. The personal property should be inventoried and safeguarded. If there are expensive rings laying around the house and caregivers coming and going, they probably should be secured somewhere where they're safe. And any other, if there are collections that are of value, you really need to make sure that that they're not exposed to outsiders. And then each county, although it varies from county to county, some are a little better than others, but most of the counties have some process of checking in on you and doing monitoring of you, other than your accountings. And in fact, in Hunterdon County, they've got a program where volunteers will actually go out and visit the ward and follow up on the accountings and talk to the guardians. So if that's in place in your county, you obviously want to cooperate with that process.
So now that you're the guardian and we've gone through what your requirements are, generally your day-to-day work will be around making decisions for the person. That's really the crux of what being a guardian is. So we wanted to talk to you a little bit about how a guardian makes decisions. It's not as simple as doing what you please as the guardian. There are certain precepts of how you make decisions as a guardian. As a general principle, a guardian must act in the best interests of the ward, which means not making decisions that will cause a conflict of interest, being loyal, not being self-serving, and giving full disclosure. And these are all just inherent and probably common sense of things that you should do as a guardian. What's a little bit more complex and maybe unknown is the different tests for decision making. There are several Supreme Court cases about this type of decision making. that's been set forth in our country about how you're supposed to make decisions. So the first test is called the substituted judgment test. Essentially what this means is it requires the guardian to attempt to reach the decision the ward would make if they were able to choose. This is essentially a subjective determination based on what the guardian knows of the ward's preferences, wishes, and desires. So essentially what you're trying to do is align your decision-making with the ward's own definition of well-being and values. It could be regarding their religion, just the way they lived in general. If you know this person for a long time, let's say if it's an elderly person and they were confident all their life, you want to try to make decisions how you think they would have made decisions in their life, whether they value material things, they may not value material things, friends that they care about, things like that. And if it's an individual with developmental disability who, let's say, just turned 18, the same rule applies. I mean, oftentimes those with developmental disabilities do have some capacity and do have preferences in their lives about friends they choose and hobbies they have and just anything about how they live their life. So you really always want to try to ascertain the board's preferences and make decisions to the extent reasonable in that way. Even if you don't really know a lot about the ward, for example, in the Office of the Public Guardian, where they become guardian for elderly people who have no family or friends, it's still the guardian's job to try to get as much collateral evidence as possible so that they can try to exercise substituted judgment. So for example, if it's someone you don't know and you've become guardian or you don't know them that well, you would interview family, you would interview friends, you would review their past acts, look for any writings you could find, so you can try to figure out how they live their life and so you can make decisions accordingly. The substituted judgment test should be employed unless it would be unreasonable or simply not feasible. So the best interest test is also often employed where the person, let's say, was never competent. It could be from a very significant developmental disability where they were never really able to express their desires or voice their desires. Substituted judgment may not be realistic. In other words, the guardian simply may not know the choice the ward would have made if they were able to do so. In such a case, the guardian should make decisions that are in the best interest of the ward, consistent with accepted societal values and norms. So again, it's not really making the decision the guardian would make. You have to try to act what's reasonable and acceptable in society. And again, that's hard to do, but again, substituted judgment is preferred if you're able to know what the ward's wishes are.
Yeah, and keep in mind that that's the test you would use even if there's a full plenary guardian. Obviously, if a person has a limited guardian, they're going to retain certain authority to make certain decisions. That legally they have the right to do that. But even under a full guardianship, their preferences, to the extent they're reasonable, they're consistent with past preferences, and it's feasible to do, you have an ethical obligation to carry that out. So the substituted judgment test is always preferred, regardless of the nature of the guardianship. We only have a few more slides. We want to sort of go through these quickly because we want to save some time for to see what some of your questions are. But quickly, obviously, a guardian is entitled to compensation. In cases of family members, in many cases, they don't take any commissions, but you should just know that there's a percentage, 6% is due, potentially on the income, 0.5% of the corpus a year, and then when the guardianship terminates, the guardian is entitled to 2% of the corpus as their commission. Banks can also serve as guardian. They are not held to those same standards. They can charge, under the rules, they can charge a reasonable commission, whatever that means. It's typically 1.5%, so it's a little bit higher than the statutory amount. And if a guardian engages in, extraordinary activity or of a professional nature in many cases, they can request commissions beyond the statutory amounts. A guardianship is terminated essentially, obviously, when the ward dies, that would terminate the guardianship. And then the other way it can terminate is if a person regains competency. We don't see that a lot, but it could happen if someone had a traumatic brain injury, let's say, and recovers, or had a stroke and recovers. That could lead to a termination. In fact, the guardian would have a duty to go back to court to have the person restored, an ethical obligation.
You may also see that in the mental health context,
Right.
where someone recovers from an episode of their mental illness and then they're restored to capacity.
Yeah, that's really for another webinar too.
Right.
The mental health field is this is a difficult tool for the mental health population because of that reason. They have times when they are incapacitated, but there are times when they regain capacity, so that's difficult. When a guardianship terminates, the guardian has an obligation to turn over the estate to the estate, the representative of the estate, the executor or the administrator, and you should file a final accounting and an application to be discharged so that there's no lingering liability after you've completed your services as guardian. And this is our last slide, and it's essentially we wanted to let you know that, as I alluded to before, that there are alternatives to guardianship. If a person has some diminished capacity but is still able to understand who their family members are and the fact that they're giving authority away and that there are certain risks attendant to that, they may have capacity to sign a power of attorney or an advance directive or a living will or a trust to have the assets moved into a trust and have a trustee manage the assets, or a conservatorship. We talked about that before. And again, the law requires a good faith effort to try these least restrictive alternatives and sort of exhaust that before you file for guardianship. But the guardianship really is should be a tool of last resort in these types of cases. Okay.
So I think we're going to take, I don't know if we're going to take questions from the organizer or if they're going to speak about the Family Resource Network first.
Did you send it over to?
Change it. Who should I send it to?
Okay. Can
Hello?
you, hi.
Hi.
I was going to talk about FRN for a few seconds. Did Andrea send you my PowerPoint? Let me do that.
No.
Dot,
No? Okay.
Dot,
Yes.
I'll put it up.
Okay, thank you. Okay, so yes, we do have a few questions, but before we get to those, I just want to talk for a few minutes about FRN services. Thank you very much for your presentation.
Okay.
It's a relatively new service for us and was developed as an alternate way of getting through the guardianship process. As many of you may know, the DDD Bureau of Guardianship Services no longer provides any financial assistance for families seeking guardianship, and the wait for them to be able to do guardianship is many years long. So also some of the audience members have indicated that they're aware of the pro se process, and that's what we help families to do if they're interested in the pro se process or representing themselves in court. We just walk them through that process so that they make sure that everything is done the way the court wants it done. it's really guidance and support. It is not a legal service. And if a family presents a situation to us that we feel requires legal advice, we will definitely recommend that the family seek legal advice. Our representatives work together with the family or person seeking guardianship of their loved one to complete the paperwork, meet the deadlines, and keep the process moving along until the judgment is received. So it's a basic support service, basically. Okay, so we have some questions from the audience, and one of them is, the first one was, if you could just speak a little bit more about the difference between power of attorney and guardianship.
Essentially, the difference is a power of attorney is what's known as a voluntary arrangement, which means the person who's giving the power of attorney, by definition, has some level of capacity to name someone. A power of attorney is generally someone giving authority to someone else to help manage financial transactions and financial issues. But again, it's voluntary, so the person giving the power of attorney must have some level of capacity to do so. And oftentimes, in developmental disability context, we find many consumers who do have that level of capacity to name a sibling or a parent or a friend to serve as power of attorney. The key in that relationship is to find someone that you trust and who's going to be a good advocate. A guardianship is what's known as an involuntary arrangement. So the person doesn't have the capacity to choose who they want, so an arrangement is imposed upon the person by the court. So it's involuntary. The other major difference is a power of attorney, because it's voluntary, can easily be revoked by the person giving it, where a guardianship is a court action and you have a court judgment, and it can only be revoked by going back to court. So a guardianship affords much, much more protection, but it's more depriving of autonomy. So that's the essential difference.
Okay, thank you. Another question was regarding divorced parents that both have legal custody. Can they both be guardians over decision making? And also, someone asked if parents often do that, become co-guardians.
We actually have several cases in our office like that, and I've been appointed as the attorney in several situations. And it depends on the relationship between the parents. You could essentially do whatever you want. If when the child was a minor child and both parents have legal custody and they are working together and they're both making decisions, and absolutely, even though they're divorced, a judge can and would probably prefer to appoint the parents as co-guardians so long as they can cooperate with each other. On the other hand, we've had a case in our office where both parents have legal custody, but one parent is the one making all of the decisions and the other parent is essentially not involved. And in that case, the mother in that case applied to become the sole guardian because the father just, not in an adversarial way, he just wasn't as involved day to day. And if one parent's not appointed guardian, it doesn't mean their parental rights are terminated. It just means that, if let's say the child needs a medical procedure or needs to go to the hospital, the doctors are only going to look to the one parent to make that informed consent. So really, it's case by case. However it's managing in that particular family is how the guardianship should proceed.
Thanks. Someone said that they have the pro se forms and that on those forms it presumes that the physicians are licensed in New Jersey. Is that required? Because there are families that have physicians that are out of state, New York, Pennsylvania, and Philadelphia. So that has come up before. Can you respond to that?
You know, it's been a while since I looked at that rule, but I think if they're licensed in another state, I think that qualifies them. I'm pretty sure. I can't say for sure, but I think if they were, you know, duly licensed in another state, that would satisfy the requirements.
I mean,
whoever asked that,
yeah.
if they want to contact our office, I'm
Right.
happy to look at the statute. But there's a statute that it clearly defines that.
If they can email us or call, we'll look that up for them.
Yeah.
Great, thank you.
Yeah.
What is the background of the court-appointed attorneys that would be appointed to represent people with disabilities?
That he has a law degree. I mean, that's a good question in the sense that
Right.
he doesn't have, you know, a lot of times he or she may not have experience with these cases. Sometimes they're on a list of appointments the court has, and they go down a list, and whoever's on that list at any given time gets that appointment. So, you know, we're involved in cases a lot of times when the court-appointed attorney is not sensitive to some of these issues that we're talking about, like what their role is, you know, the role of the guardian ad litem, and so it's a little frustrating sometimes. But the answer is, you know, each county is different, but they don't necessarily have to have any background in this area.
Yeah, I was going to say it's very county specific, unfortunately. So depending on what county you're filing in, some judges will take the time. Let's say if it is divorced parents, some attorneys are more sensitive to those issues. Many judges will handpick the attorney for a specific matter. So some judges are more sensitive to the facts of the case and will handpick who they think will be good. And like Tony said, others will just appoint off the list. So it's very county specific.
Yes. There were a few questions about how long the process takes and also when to start. And I think your comment about each county being a little different is one that we've found to be true. In some counties, they will let you file a little bit before the person turns 18, but they won't schedule the hearing until after they turn 18. In other counties, they don't want it in advance of the 18th birthday. So could you talk about that, and then about a little bit about how long it generally takes?
Yeah, that's generally true about 18. But when you apply and you have your doctor reports, that usually is what takes time. Once you get your doctor reports and you're ready to file, you know, within a couple of days or a week or two of that filing, you're going to get, you know, what's called an order to show cause or an order fixing date for hearing. Setting that down for a hearing, you know, typically within the next 45 days or 60 days. So it's going to move fairly quickly, really in all counties. There may be some counties a little slower than others, but it's not going to be 6 months or 8 months. You're going to get a hearing within the next 2 months. And in that time, that's when that court-appointed attorney will do their job. They'll get appointed in that order, you know, that order to show cause, and then they'll go out and do that investigation and report to the court. If it's not a contested case, and there's no need to get other medical reports, you know, that case will probably proceed on that scheduled date. It may be an adjournment for someone's schedule, you know, but typically it's going to go right around that time. If it's contested, that's a different story.
Right.
And we've been involved in cases that take 2 or 3 years, depending on, you know, on what the nature of that contest is. You know, if it's the kids fighting over, you know, who's going to manage mom or dad, you know, they could be litigating that thing for a while.
Right.
You know, and that's why some counties will go to mediation. Some counties, that role of court-appointed attorney becomes important in cases like that also, because sometimes they can help negotiate a settlement on behalf of the alleged, knowing that, you know, the person maybe truly needs a guardian, is really not advocating or not, you know, not really contesting it, but it would be in the person's best interest to have the issues resolved. So that attorney may take an active role in trying to resolve that conflict.
There are a few more questions. A few I think have already been answered, and certainly making the decision about guardianship is a very personal one, and no one can answer really for you whether guardianship is the best thing. You certainly can discuss that with an attorney to see if they have an opinion, or if you have a physician or a psychologist that you trust that could give you an opportunity to talk it through, basically. There were some more questions about co-guardianship as well. When something happens to, where there's an elderly parent, and we're talking about guardianship of an individual with disabilities, that's a sibling perhaps. The question is, should I become co-guardian with my parent now so that if something happens, I will be the guardian when that happens?
You know, that could be a very good tool, actually, because in New Jersey, there's no provision for what's called a successor guardian. So let's say if one generation is appointed guardian for a parent and something happens to that person and they can no longer be guardian, you would have to return to court to have a substitute guardian appointed. Whereas if you do have co-guardians at the outset and something happens to one of the co-guardians, the other one, there would be a provision in the order that the other one would continue to serve alone. So, but again, it really comes down to how you can work together. If you feel you can work together without too much controversy and make decisions expeditiously, and if you share the same value system and wishes for the parent, then a co-guardianship could work wonderfully, and it can alleviate some of the burdens and the pressure off each co-guardian. But if it's a recipe for conflict and you don't think working together will be harmonious, you might be better working one at a time. I mean, either way, if there's only one guardian and you do need to return to court to appoint a successor, you know, it's not the end of the world, and you don't have to reinitiate the entire guardianship proceeding. It's more of a simple proceeding to have a substitute appointed. So it really is case specific on how the family is working at that time.
Right, definitely.
Mm-hmm.
I think I'm just going to do one more question about some of the alternatives. Someone asked if it's okay to use more than one of the alternatives, like having an advanced medical directive and power of attorney, or I don't know what other combination they were thinking of, but that was their question. And then the other question is, can they have your PowerPoint?
If they email us,
Yeah.
yeah, we're happy to give that out.
Okay.
Give our email now.
So,
Is
was
our
it
email
on? Was it on the PowerPoint? I think it was.
Our website is on the last slide, but I can give you
Well,
an
you
email.
can switch it back to yours if you
Yeah,
want to.
sure.
But to answer that question about different alternatives, yeah, you could. I mean, certainly a power of attorney is usually just for financial matters. So you would have a power of attorney, and then have the person sign an advance directive for medical. That's usually designed for medical reasons or medical issues. So you have those two things. And I can envision a situation where you have that, and then you might have a living trust of some sort set up. You can have that in combination with those two. So there's different ways of doing that depending on the circumstances. But it really comes down to, as Nina pointed out too, is if the person is objecting, even if the person has some capacity to do a power of attorney, but is going to be objecting to what's going on and is hostile or becomes hostile to that person, to the attorney in fact, and is making bad decisions, at least in the eyes of the attorney in fact, then you may not have any alternative but to go to seek guardianship because the person is not cooperating. So that could be a situation where you need guardianship even though you may have power of attorney because the person is not cooperating.
All right. Okay. So there are other questions. I'm thinking that maybe Tony, Nina, and I can look at those offline, and we have the list of participants, so we will be able to answer some of those other questions back to the group after the webinar. Someone did ask about, I believe, about the webinar being available after tonight, and it will be. It will be posted on our website, and so people can listen to it, or you can tell other people about it. I want to apologize again for the delay in getting started, technical difficulties. When we log off of the webinar, when we end the webinar, participants will immediately be asked to respond to a survey. And we have talked already about doing a follow-up webinar on guardianship, Nina and Tony and I, regarding limited guardianship. We have not selected a date, but we're fairly certain that will be our topic, but we also are asking for your input on the survey. If you have other topics that you would like to have us cover regarding guardianship, we'll be looking at those as well. So thank you, everyone, for your patience in the problems in the beginning. Thank you, Nina and Tony, for your presentation, and hopefully we'll be able to answer all those other questions through email.
Okay, thank you, Dot.
Thanks. Good night.
Dot.
Yeah, oh good. I was just going to call you.
Oh, okay, so
Right. Oh boy. Oh boy. So
do you want to end the call or do you want me to?
I will, but I just